Good afternoon, everybody. Thank you for joining today. My name is Barak Hershowitz, and I am the president of the International Luxury Hotel Association. I'd like to welcome you all to today's webcast. The title is The Hospitality Industry Takes the Hardest Hit Under Healthcare Reform. It's part of a series of webinars that the International Luxury Hotel Association has been presenting on hot topics in the hospitality industry. Before we get started, I'd just like to take a minute to talk to you a little bit about the International Luxury Hotel Association. About 6 years ago, in 2008, we started as a small community online, a LinkedIn group of about 500 hoteliers. We formed the group with the purpose of hoteliers around the world being able to share ideas and insights of what they were doing in their part of the world in their hotels. And it became a very valuable resource for our small community. A hotelier in one country could chat to another one and find out, how they're handling things like, is their hotel offering free Wi-Fi? Are there guests? What type of a guest experiences they were offering and things like that. So it became very popular. Within a space of time, we grew from 500 hoteliers to 5,000 hoteliers, from 5,000 hoteliers to 50,000 hoteliers. And before long, we reached 100,000 hoteliers. Today, we have over 275,000 hoteliers worldwide. We pretty much represent everybody in the hospitality industry, from people working in hotels to people that own hotels, to people that manage hotels, to people that design, decorate, just about everything, supply hotels. So we're really a large representative community. We're actually the largest online community of hotel professionals in the world. Currently, we are ranked #1 by LinkedIn out of the over 4,500 hospitality and travel-related groups for both our size and our activity. Just over a year ago, our community voted to form a professional association, the International Luxury Hotel Association. The reason they did this was because they felt that there were a number of associations specializing in the luxury hotel industry, but they were mainly focused on marketing of hotels for corporations. And they found that our online community was filling a need for them, a place where they could come to learn a little bit more about the industry, find out what other hoteliers are doing. They could educate themselves on the latest trends. With the luxury hotel industry, what tends to happen in the hospitality industry in general is that most of the trends are set in the luxury segment of the hospitality industry. So even though our group is focused more on what's happening in the luxury hotel industry, we became the largest hospitality group in general because people in the other parts of the industry were coming to us to see what sort of trends were happening, and also if they were working in another area of the hospitality industry and they wanted to move into the luxury hotel industry, they came to us to find out, to educate themselves to the level that they could, so that they could transfer across. And these are things that the association, they felt that our community was helping them with, but they wanted to take it a step further. And they felt that there was a need for an association. So over the past year, we've been working tirelessly with the community of hoteliers and also leaders in the industry. We have we've had a lot of input, and we have a strong board of advisors from executives working from top groups like Trump and Ritz-Carlton and Preferred Hotels, and so we have a really strong guidance and the backing of really the largest hospitality community in the world to get the association going. We started off introducing some benefits for our members. This is about a year ago. Let me just get over here. So we started the association, and we started introducing some benefits from our LinkedIn group, as I mentioned. We started creating subgroups, which have become very popular. For instance, our general manager subgroup now has over 9,000 hotel general managers that belong to it. We have one for technology, sales, and marketing, and these have become almost specialized sections of our group. We also introduced our Smart Brief on luxury hoteliers. Smart Brief is it's about a year and a half old now. It is a a daily quick read summary of everything that you need to know in the hospitality and the luxury hotel industry. So we have a group of editors that get up very early in the morning. They scour the web for every possible hotel, hospitality news site, and find out what's happening in the world of luxury hospitality. And then they create a quick read summary of this news, which is delivered for free to hoteliers. We now have over 8,000 hotel professionals that read it every single day. So that's one of the benefits that we first introduced, and it's become incredibly popular. In fact, I would go as far as to say that it's probably now the leading news resource for people working in the luxury hotel industry. Our next slide over. The next thing that we also added, recently launched, is our Luxury Hoteliers magazine, which is at luxuryhoteliers.com. Luxury Hoteliers magazine the articles are contributed by members of our community who are leaders in the industry, and they give us insights into what's happening, the latest trends. As I mentioned earlier, a lot of what happens in the hospitality industry starts with the luxury segment. And so, for instance, if it's related to design, technology, guest experience, guest service, all these things usually start in the luxury segment. And so we've tried to speak to our leaders and find out what are the hot topics at the moment, and they've given us some insights. So this magazine is becoming, which we've recently launched, has become incredibly popular and is a great tool for our members. We also have on our association website, we're busy putting together a resource center where we'll be housing some of the webinars we're doing. We're going to be also accumulating and partnering with some top hospitality organizations around the world to get research and white papers for our members where they can go and really find out, investigate research and find out what's happening and inform themselves better. We're also starting a certification program. Our first certification program, which we're hoping to have, which we've started working on already, is for the wellness side. So we'll be offering a wellness certification for hotels and people working in the wellness side, specifically in the luxury segment of the hospitality industry. So these are all things that that the association has started doing and that we're going to continue to do now that we've recently launched. We also will be holding workshops both online and offline. We have a event coming up, a workshop that we're going to be holding in London at Hotel Olympia at the end of April. We'll be having a conference in September, which will be hosted in Washington, D.C. So there's a lot happening. It's an exciting time, really, for anybody that's working with or around the hospitality industry that's interested in the luxury segment. I highly recommend that you get involved with us. One of the benefits, one of the things that we've done, because we're a community, our association is kind of unique. It started with an online community. We wanted to include all our members that have supported us and give them a sort of special designation. So anyone that joins the association by the end of March, before the end of March, is given a designation of founding member. It appears on their certificate. It's something they can use on their resume and on their and also on their LinkedIn profile. So we've had it's definitely a way of recognizing those that have helped us get to this point. Very, very exciting. So I'd like to invite anybody that is interested in finding out more about the association or would like to join to visit luxuryhotelassociation.org. And there's information there, and you can sign up, or feel free to contact me after the webcast, and I'll give you any information you need. So at this point, I'd like to introduce our distinguished guest today to talk a little bit about the webinar. This webcast, the topic is the hotel industry takes the hardest hit under healthcare reform. It's a very, very important issue here in the United States for our members that are based in the U.S. And so our special guest today is Jonathan Edelheit. Jonathan is the Chief Executive Officer of the Employee Healthcare and Benefits Congress, which is the largest U.S. insurance and HR convention. Jonathan is also the founder of the Healthcare Reform and Center and Policy Institute, which is a think tank which brings together leaders in the industry really on professional development and healthcare reform. Jonathan is also the Jonathan used to be run one of the largest healthcare administrators in the United States, and is considered an industry expert on healthcare in the United States and actually internationally. He's been featured in media all over the United States and abroad. Without going further on, Jonathan really is one of the top people on this. I would like to invite him. Thank you, Jonathan, for joining us today. We're honored to have you.
Thanks, Barak, and great introduction to Ilha. Really excited to see everything you're doing in the international luxury hotel space and really filling a gap and a need that's really, hasn't been filled before. But so I think it's going to be neat to see the activities and how you really bring the industry together going forward. So I'm the president of the Healthcare Reform Center and Policy Institute, and we are the leading educator here in the U.S. on healthcare reform. We do a lot of healthcare reform workshops and training and certification all over the country online, and we also work with the administration on educating the public. So we've worked with the HHS, DOL, IRS, all on telling the U.S. insurance industry and the HR industry what's going on with healthcare reform. So I think the topic today is really critical for the hotel industry. I think that healthcare reform is one of the hottest topics for U.S. hoteliers because they're the most affected by it, simply because you have a lot of part-time, a lot of hourly, a lot of 1099, because of that, you run the risk of having to comply with the law, getting fined, and other issues. And so you really have to stay on top of the law, and you have to plan now because of things like the measurement period and other factors of the law. That means that you cannot wait until the last minute in how you designate employees, how many hours they work, because the IRS is going to have a look-back period and some other things that can have a big impact on you as a hotel. So although there have been delays in the employer mandate and it's given everyone time to consider the best strategy, it doesn't mean you really don't have time. You have time to sit back and relax. If you're in the hospitality sector, you face the greatest cost increases with some of the provisions of the healthcare reform law with the penalties that are going to go in effect January 1st, 2015. So you got to start your measurement period now. If you don't know what a measurement period is, you're going to learn very shortly, and it's going to be something extremely important and critical to your business. You don't want to find out, you have a couple thousand employees and you're being hit with a several $1 million fine starting January 1st of 2015. That would obviously be devastating to your budget and the impact of your organization. And today we're going to learn with our webcast about the special relief afforded mid-sized employers, how to measure variable hour employees to determine full-time status, how to measure the hours of individuals who do not work traditional schedules, how to avoid the litigation pitfalls inherent with the ACA implementation, the Affordable Care Act. Will the marketplace prove to be an effective means of delivering insurance? Do private exchanges prove to be a viable alternative to state or federal exchanges for your employees? And who's eligible for coverage under the exchanges in the new marketplace? So, for our presentation today, the Healthcare Reform Center and Policy Institute, we're a national nonprofit organization, and what we do is we work with our instructors who are the top healthcare reform experts in the country. They don't get any better than the people that we bring for instruction. So these are people who they're the ones who helped draft the bill and actually worked in Congress or in the administration, to the people that are in D.C. and dealing with the Department of Labor, HHS, IRS every day in regards to the law and submitting, papers and other things for changes to the law. So they're the biggest influencers in the country, and they know what's happening and they know what's going to happen, meaning they know what's going to happen a couple months from now before anyone else does. So I'm really excited for our presenter today, Jim Napoli. He's a partner in the Washington, D.C. Metro office of Constangi, one of the top law firms in healthcare reform here in the country. He has experience litigating benefit plans, long-term disability, employer-sponsored medical plans, and insurance contracts. He served as counsel of record on an amicus brief filed with the U.S. Supreme Court on behalf of the American Benefits Council in healthcare reform litigation. He's participated in settlements of, for example, of Chrysler's nearly $10 billion retiree medical obligation. And he also counsels employers on all aspects of their employee benefit program, including tax-qualified retirement plans, 401k, traditional defined benefit plans, executive compensation, cafeteria, COBRA, and other group health plan issues. So he's really great. And one thing that I advise you to is, there's a question box where you can ask questions. So feel free during the webcast to ask questions. We'll answer them during or after the webcast at any time. And for those of you who are wondering, we are going to be recording the webcast and making it available on the International Luxury Hotel Association's website in just a few days. So with that, I'd love to turn it over to our expert, Jim Napoli.
Thank you, Jonathan. I think we have a great program for you this afternoon, and I was very happy to be asked to provide this or to present on this program because I have some experience working with the hotel industry on the employee benefits side, and I can tell you that the relationships within the industry vis-a-vis ownership of different hotels, the different types of employees or workers that are used throughout the industry makes it a very taxing exercise to determine how the Affordable Care Act really impacts the hotel industry and the direct and quite frankly harsh impact that healthcare reform will have on the hotel industry by way of the additional cost. So what I wanted to do is start with some initial observations, and then we'll walk through the final regulations on the employer mandate, at least the highlights within the final regulations, talk about some of the transition relief that was given. Then we'll discuss how to determine employment status. Again, there's various different types of workers within the industry, so we'll want to go over the rules of the road as to how to determine whether an individual is or is not an employee for purposes of the Affordable Care Act. Looking at a few special classifications, and then we'll look at the determination of full-time status. And as Jonathan alluded to, there's a look-back approach, measurement approach that is been given to us by the under the final regulations, and most employers are going to look to use that approach, and we'll talk about that, and we have a couple good graphics on how that works. Then we're going to talk about the employer response to the employer mandate. So that's really getting down to the nuts and bolts and what is the downside, what are the downside risks that you'll face in terms of implementation. And that's one of the things that I'd really like to focus on today is as we're going through the technical rules is to remember in the back of your head a couple of things. Number one, we are now in an era of good faith compliance. The regulators know, the administration knows that there are still rules to be written. As a matter of fact, within the final regulations on the employer mandate, it's stated that there will be additional rulemaking after these final regulations. So in some respects, the final regulations aren't even final. That being said, the administration has taken the position that we are in the good faith implementation part of implementation, and what that means is that you want to know the rules, and in implementing them, you want to take reasonable, good faith efforts. That means you're going to want to really think through the implementation, look at the rule not only on the black letter, but what it means, what's the spirit of the rule, and that should help guide you in your decision-making process. And we'll talk about specific examples as we get deeper into the presentation. But I just want you to have that in the back of your mind. It's all about good faith, reasonable interpretations, reasonable implementation. And I think if you use that as your guide and then follow some of the steps that we're going to discuss in just a bit, you're going to be in a very good position should the government come knocking on your door for an audit. And I will tell you this, going into it, the federal government already is auditing on the Affordable Care Act and implementation of the Affordable Care Act. Those audits go beyond just whether or not the plan is grandfathered. It goes to how employers are classifying certain individuals. I've had more than a couple now clients already contact me who are under audit or scrutiny as to classification issues. That's been something that's been with us for some time, but now with the Affordable Care Act, it's taken a heightened sense of urgency within the agencies. So let's start with initial observations. This is the current healthcare reform system. This is the administrative system that is set up or is being set up to implement healthcare reform on a national level. Now, the typical employer response to this has been one of frustration. As I said, the infrastructure is still being built, and employers are being asked to make 100% decisions with less than 100% information, and in fact, sometimes making decisions where there is really no rule of the road that's been created yet, so taking a reasonable good faith approach. That's not comfortable, a comfortable position for employers to be in. Now, when you look at this, what you're going to see today is that you can be 100% ACA compliant, but still violate a series of other laws. There's ERISA that we have to concern ourselves with. There's employment law issues, labor law issues, certain state laws, and other federal laws. This is not an exhaustive list. Now, when I start to speak to my clients about this aspect of it, again, you can be 100% ACA compliant, but yet still violate the law. The response is typically one of extreme frustration, almost to the point of anger. The good news is, if we really pay attention to the rules, using good faith compliance as our guiding principle, and then keeping in mind some of the things we're going to discuss today, there's really, obviously we're going to be frustrated anytime there's new rules put upon us and those rules have cost. There's a level of frustration. But we should at least be in a position where we are comfortable with what we're doing, and that we're comfortable that in implementing our strategies the way, in an appropriate fashion, that we are going to be protected, whether it's against an audit or whether it's against a lawsuit that the employees may bring. And we'll talk about what some of those lawsuits may be later this afternoon. So let's talk about the transition relief. The final regulations make it clear that the transition relief, under transition relief, that the effective date of the employer mandate is based on the plan year. So for calendar year plans for large employers, the employer mandate is effective January 1, 2015. If the large employer has a fiscal year plan or a non-calendar plan year, then the mandate is effective the first day of the first plan year following January 1, 2015. Now, this is for the applicable large employer with 100 or more employees. We're going to talk about in a minute special transition relief for what are called mid-sized employers. The requirement to cover dependents will not apply for the 2014 or the 2015 plan year so long as the employer didn't offer coverage during 2013 or 2014 and the employer is taking steps to arrange for dependent coverage prior to the beginning of the 2016 plan year. So again, this is an employer. The rule is effective for large employers 2015. You have to provide an offer of coverage to each full-time employee and their dependents. Now, if you fit into this transition relief here, meaning you previously have not provided dependent coverage, but you're seeking to get that coverage put in place in 2016, you don't have to provide the offer of coverage to the dependents for 2015. Okay, an employer who employs 50 to 99 full-time employees, a so-called mid-sized employer, they do not have to comply with the employer mandate, or the employer mandate isn't effective with respect to that group until the first day of the first plan year commencing on or after January 1, 2016. Okay, so for large employers, 100 or more employees, We're looking at the first plan year that begins in 2015 as the effective date of the employer mandate. For the mid-sized companies, an employer who employs 50 but no more than 99 employees during the year, we're looking at the first plan year of commencing in 2016 as the effective date. Now, there's an anti-abuse rules with respect to this transition relief. The first says that the employer cannot reduce the size of its workforce or overall hours of its workforce to cut back so that it fits within this 50 to 99 employees. So what that means, frankly, is if I currently have 107 employees on my payroll, I can't terminate 8 of them so that I'm now at 99 full-time employees and therefore have until 2016 to comply. You can't do that. Now, if you have legitimate business reasons, that's a different story, but you can't do it for the purpose of take that action for the purpose of falling within this transition relief. If the employer currently provides health coverage, the employer cannot materially reduce or eliminate that coverage. And again, what that is for is so that if an employer has already has coverage in place that would be compliant with the Affordable Care Act on the thought that, the employer mandate will apply in 2015, that employer can't say, well, look, now I've gotten until 2016, so I'm just going to drop the coverage altogether, or I'm going to cut it back to a skinny plan that doesn't really provide much in the way of benefits until 2016 when I have to provide the more robust coverage. Can't do that. And the employer is going to have to certify to the IRS that it meets these criteria, and that certification will be through the annual reporting that's going to be due to the IRS. And we actually just received late last night final regulations on some of the reporting and disclosure requirements. So look forward to some more information on that in the coming days. Now, in determining whether I am a mid-sized employer employing 50 to 99 employees, I can look back for 2015. I can look back to any 6 consecutive months in 2014 to make that determination. Now, the question then becomes, well, what's in it for large employers? Okay, we know that small employers, those who employ under 50, aren't subject to the employer mandate altogether. We now have this special relief for mid-sized employers that basically says they are not subject to the employer mandate until the first plan year beginning in 2016. What about large employers? Do they get anything? Those that employ 100 or more employees? And the answer is yes. For 2015, the threshold level for the level of offer that the employer has to make is 70%. So what that means is that the employer must make an offer of coverage to at least 70% of the employer's full-time employees and their dependents unless the special exemption for dependent coverage applies that we just discussed. In 2016, that reverts back to the rule prior to the final regulations, and that's 95%. So the employer, in order to avoid the penalty for the failure to provide an offer of coverage to full-time employees, in 2015, the employer has to make that offer of coverage to at least 70% of the employer's full-time employees, and for 2016 and beyond, it's 95%. Let's talk about determining employment status. Now, this is a big issue. This is a big issue for this industry. It's a big issue for other industries. The final regulations adopt the common law approach to determining whether an employee-employer relationship exists. So what that means is if you have statutory exemptions or you have a statute that defines what an employee is for purposes of employment law, let's say, or for purposes of tax law, push those statutes to the side. The approach under the Affordable Care Act is the common law approach. And what that means is you're looking at generally control. The IRS has about a 26 element test for determining employment status. it basically boils down to a few categories. Number one is who has the right to hire and fire? Who has the right to terminate the individual who's providing the services? Who has the right to dictate the timing of those services, when those services must be performed, when the individual must show up and where they must show up to provide the services? Who has control over the way, the methods that are used for performing the services, and who provides the instruments and the other items necessary to perform the service? It's that entity with the control over those elements, or a number of those elements, it doesn't have to be each and every one, that will be viewed as the employer of that individual. We'll talk about that in a little more detail. Now, the regulations do define an employee to exclude leased employees, sole proprietors, partners in a partnership, a 2% S corporation shareholder, as well as real estate agents and direct sellers. And again, that's not necessarily much of a surprise because traditionally we have treated those individuals as non-employees under federal tax law and employee benefits law. The final regulations do not provide a safe harbor of definition for independent contractors, nor do the regulations provide relief for industries that employ the so-called high turnover employees. Now again, this is important. It makes sense to me, at least, that there would not be a definition of independent contractor under the final regulations, in as much as the final regulations adopt the common law approach for determining employees. So what that means is I'm using a facts and circumstances test to determine whether one is an employee or not. Now, in determining whether an individual is an independent contractor or not, it's typically going to be a facts and circumstances test. I'm going to look at the control elements again. So that's very important. And what that means for you as an entity is when you're going back and looking at the individuals who work for you, you have to really have a good understanding of what their position is and who has the ultimate control over that individual. That's then going to drive whether the individual is going to be treated as your employee or as a non-employee. To the extent you feel that there is an individual or a group of individuals who are not your employees, what you need to make sure you do is adopt a policy that defines these individuals as non-employees, and within that policy, have a brief explanation. I'm not talking a book here. I'm talking a one-page, few paragraph, maybe it's a two-pager, depending on how complicated the relationship is, policy that states why these individuals are not being treated as employees. The reason that you want to do that is so that if you are ever audited on the issue, or if you are brought to court because a group of individuals sue you saying, hey, we were your employees, you should have made us that offer of coverage, we were excluded from the plan, that you have a written record as to the policy showing and is showing that you followed that policy. I have a number of clients over the years who have been audited on worker classification. Those who have strong written policies, so long as they follow those policies, it's always been pretty easy to defend them in front of the IRS or the Department of Labor. It's those that don't have the paperwork to back what they're doing where it's much more difficult to defend. So that is tip number one for today, is to make sure that you're documenting. Now, when you do this, and I'll talk about this a little later too, is you're going to want to do this in a privileged manner. So these decisions, when you're discussing about who's an employee, who's not an employee, how we're going to be applying the common law principles, you don't want to have these discussions in a non-privileged manner. What that means is you want to have legal counsel involved at some level so that you can have attorney-client privilege. You don't want to have to hand over all of your work product, hand over all of your conversations about these issues where quite frankly, you may have said something that can be misconstrued if taken out of context. You don't want that to be presented in an unprivileged manner. Why? Because if it's not privileged, if it's not subject to privilege, the government automatically gets it, as does the opposing counsel to the extent you're sued by employees. So that's tip number 2. Number 1, make sure you have good written documentation. Number 2, to the extent you can, try to get that in a privileged manner. Tip number 3 is these discussions should not be made through email. I know that email has become a very comfortable place for employees and you and your colleagues to speak and discuss issues. Email wasn't really meant for that, and particularly when you're talking about issues that have major legal significance to you, you do not want to be having a written conversation via email that is papering, again, everything that's being said, because those can be taken out of context. As a litigator, I'm both a substantive practitioner as well as a litigator. It's very difficult when you get that string of emails that just looks very bad. It makes it difficult to get the case dismissed early on, which means more attorney's fees, which means more cost, which means more lost time as employees have to be called in as witnesses and whatnot. So you want to make sure that you're not having these conversations in email. What you might tell, if you are the HR professional that's in charge of implementation within your team, what you might want to tell your team members is what I tell my clients, and that's this. If you send me an email and I respond back with a great question, let's have a call on that. What I'm telling you is, we're going to speak about this now. There's no more writing on it, no more emails back and forth on this issue. It's something we need to speak about, and then we can paper the trail with what our actual decision is. Staffing agency workers. If an employer uses a staffing agency to hire workers and the workers are not the common law employees of the staffing agency, so that's key, they're not the common law employees of the staffing agency, then the employer will be deemed to have made an offer of coverage if. So here's the scenario. I'm an employer, I'm company A, I'm looking to hire workers through a staffing agency. As their employer, company A is I'm viewed as their common law employer because I can tell them, when to show up, where to show up. I give them the instruments that they need to to perform their job. I'm able to hire and fire them. I have all the common law elements in my favor in terms of control. If I don't have my own plan, Company A does not have its own health plan, or if I have my own health plan but it doesn't offer coverage to these hired workers, I can take credit for the staffing agency's offer of coverage to these individuals, so long as I pay an additional fee to the staffing agency for that privilege. So what we're saying here is the consumer company, the client employer, if you will, they will be deemed to have made an offer of coverage to these workers hired through the staffing agency to the extent the staffing agency made an offer of coverage to these individuals and the employer had to pay more for the staffing agency. So it's as though the employer, the client employer here, Company A in our example, purchased coverage through the staffing agency. Definition of seasonal employee has been provided, and it's actually a more generous definition than we had under the proposed regs. The proposed regs basically said, look at current DOL guidance on the definition of seasonal employee. The final regulations define a seasonal employee as an employee who is hired into a position for which the customary annual employment is 6 months or less. And now the preamble to the final regulations clarify, and this is a direct quote, that the reference to customary means that by the nature of the position, an employee in this position typically works for a period of 6 months or less, and this is the key, that period should begin each calendar year in approximately the same part of the year, such as summer or winter. So what the final regulations are doing is they're giving employers more flexibility to determine who is and who is not a seasonal employee, in response to the concern by employers that different sectors, different industries have different definitions of seasonal employee at different time periods. So what the government has come back and said is that's fine, so long as the period is traditionally or typically 6 months or less, and it occurs around the same time each year. So again, you can't just willy-nilly make up seasons and seasonal employees. You have to have some method to the madness, if you will. Volunteers, we'll just go through this very quickly. A bona fide volunteer, you don't count them as employees. Bona fide volunteer is basically an individual who works for the government or a tax-exempt organization and does not receive actual salary or pay. They can be receive reasonable reimbursement for expenses, and they can also receive reasonable benefits. Institutions of higher education, I think we'll skip this because that really doesn't apply to your industry, and we're running close on time. So I want to make sure we get to some of the real juicy stuff here, and here's one of them. Determining full-time status. Okay, so now we have our individuals that we have determined are our employees. The next question is, are they full-time employees? And if we have groups where we know they're full-time employees, and again, under the Affordable Care Act, full-time employee is anybody who works 30 or more hours a week. If I have individuals who I know are full-time, I've hired them as full-time, I don't have to worry about everything that I'm going to be talking about now. Likewise, if I have individuals who I know are part-time, and they're always going to be part-time, they can't possibly work more than 20 hours a week, let's say, because that's the way that they're, the nature of their position, and that's what their position states. That's what their deal is. Then again, I don't have to worry so much about this measurement period. What I'm looking at here are individuals who are variable hour, who from day to day, week to week, month to month, their hours vary, so that one week they may be working 28, the next week they may be working 58 hours. It varies. So there are two main methods. The first is the monthly measurement method, where you basically are measuring individuals on an almost real-time basis. I'm not going to get real deep into that because I think most employers are looking at the look-back measurement method. And the look-back measurement method is just what it says. And it's very similar to what we have on the retirement plan side. And that's where you look back to the year prior to the year in which you're actually measuring these individuals. So for 2015, I'm looking back into 2014. And then that will roll through, and I'll show you a graphic that demonstrates that. For 2016, I'm looking back into 2015. Now, before I go to the graphic, I wanted to talk about this third bullet point, communication issues. If you are making your coverage contingent upon an individual being a full-time employee, or if the offer of coverage differs based on whether an individual is a part-time or a full-time. Full-time gets more robust coverage, or full-time employee has more offers available to them, more coverages offered to them. And I need to make sure that that is communicated clearly to the individuals, and it probably finds its way certainly into at least an administrative policy under the plan, if not finds its way into the plan document itself. So what I'm saying here is, if I'm going to define full-time employee for purposes of these variable hours based on this look-back approach, I ought to say that somewhere, that this is how I'm going to be determining your status as a full-time employee. And I say that because I was recently speaking with a journalist from the Wall Street Journal, was interviewing me on some of these issues, and that issue came up where the question was, they had received a question from a reader that had the following scenario, where individuals' employer measured the employees on a quarterly basis, and based on their status at the end of each quarter, that let the individual know whether they were eligible or not for coverage. If they were full-time, if they averaged full-time status during a quarter, they would receive coverage for the following quarter. Well, employer decides to implement the look-back measurement method, and they use a 12-month look-back. And again, we'll talk about what this all means in a minute. But that 12-month, under the 12-month approach, the individual loses their coverage. However, had they known that the 12-month approach was going to be used, they could have moved around some of the hours that they had been banking vacation days, for example, where had they used, they would have counted as paid leave and therefore counted towards their average, and they would have averaged full-time. There's going to be an issue there because there was a change in the way the at least, again, at a minimum, the administrative policy for determining full-time status under the plan had changed. The individual wasn't given any information about that change. There's a question in my mind as to whether the employer should have provided that message. So let's talk about the measurement, the look-back approach, and how it works. And I apologize, my graphic did not make it into this particular deck, so let's talk it through. We have first our measurement period, and that's the look back. My measurement period can be any number of months, no greater than 12 months. Then I have my stability period. That's the period for which I have to make the offer of coverage. My stability period has to be the greater of 6 months or the length of the measurement period. So for example, if I use a 3-month look back, then I have to have a stability period that's at least 6 months. That means that anybody who is measured as a full-time employee who averages full-time employment status during that 3-month look-back period, they get an offer of coverage that would last 6 months. And I have my administrative period, and that's a 2-month period. So after my 3-month measurement, I have 2 months to capture all the numbers, run my calculations, and make my offer of coverage. And then the following 6 months, individuals who elect coverage are covered under the normal circumstances. So then if they terminate 2 months into that coverage period, they don't get the additional 4 months. They're COBRA eligible like anybody else. But they have to at least have the offer of coverage for a period of 6 months. Once they're covered, it's under the regular terms of the plan. So let's talk about how employers are responding to the employer mandate. Here's some of the practical considerations that you have to have. Some employers are reducing full-time employees to part-time status to avoid penalty on those individuals. Others are capping hours where they'll say, you know, for example, you're currently a variable hour employee, but from this point forward, from January 1, 2015 forward, you can no longer work more than 28 hours. Or they're reclassifying workers, taking employees and reclassifying them as independent contractors. Here are some of the potential risks. The first is a risk of 510, which basically says you cannot take an adverse employment action against someone in an effort to interfere with any right to which they may become entitled under an ERISA-governed plan. Now, the key here is the motivation. There has to be a specific intent to interfere with the benefits. So before you implement any type of reduction in hours or cap, you're going to want to look at the group that's being impacted and say, what is their current right to benefits under this plan? And are they going to lose those benefits under the plan? So if I take them from full-time to part-time, would they lose benefits? If they would, you have to come up with a reasonable reason other than interfering with their benefits. And you're going to say, well, that's easy. It's because I want to avoid the cost of health care reform. I don't want to have to pay a penalty on these individuals. That takes us to the next potential downside, and that's an ACA whistleblower action. The Affordable Care Act prohibits employers from taking adverse action against any employee because the employee received a premium tax credit or subsidy through a marketplace. Now, we know that the penalty under the employer mandate is, in fact, triggered by someone receiving a full-time employee receiving a premium tax credit or subsidy through a public marketplace. So if the employer is saying, listen, the reason I reduced your hours was not to interfere with your right to participate in my plan, but it was so that I could avoid the cost of Obamacare, if you will, there could be a problem there, because if I'm the participant, I'm going to say, or the employee, I'm going to say, well, wait a minute, you can't do that. The only way that you would have incurred an additional cost is if you incurred a penalty on me, and the only way you incur that penalty is if I receive a premium. So you have now taken an adverse employment action against me, reduced my hours. Why? Because you feel that I'm going to receive a premium. The courts will have to decide whether this is a good claim or not under the Affordable Care Act, but it is out there. The other thing is you have to look at the impact. This is the employment law side of it on the group that you're looking to reduce the hours. Age Discrimination in Employment Act prohibits employment discrimination against persons 40 years of age or older. Title VII prohibits employment discrimination based on race, color, religion, sex, and national origin, and there are others. Americans with Disabilities Act and others. So the question here is it a legitimate business reason under Title VII, for example, is avoiding a penalty or any additional cost under the Affordable Care Act a legitimate business reason for cutting back the hours of a group of protected individuals? So what you need to do is look at the group. If I'm going to be reducing the hours of my, let's say it's my desk staff, so the people who work behind the desk, I'm going to take them from full-time to part-time. I have to look and see, well, is that group disproportionately female? Are they disproportionately of a protected minority group? And if so, then I have to come up with a legitimate business reason. And again, the question that the courts may be asked to answer is avoidance of the tax under the employer mandate or the penalty, is that a legitimate business reason? Excuse me. And if I'm plaintiff's counsel, again, I'm going to say, well, no, it can't be. And the reason that it can't be is ACCA itself says that you can't discriminate against someone or take an adverse employment action against someone for purposes of because the individual received a tax credit. So this is no different. What the employer is doing is they're penalizing this group, and it happens to be a protected group. Not only that, but not only is it the loss of coverage that the individual has incurred, it's the loss of the wages. So there's a dual threat there, if you will, on the employment law side. So you have to really know the group that is being impacted and know their demographics. Real quick, and then we'll close it out for some questions. How to minimize the risk, maintain attorney-client privilege. We've already discussed that. Determine the affected employees and their current benefit rights. We discussed that as well. Accomplish cost savings via plan design instead. So, for example, could I say as part of my remediation, listen, I'm already providing these individuals coverage, so I will continue to provide individuals coverage who are currently covered, even though I'm going to reduce their hours to part-time, so I'm not subject to a penalty, but they at least won't lose coverage under my plan. And it will only be new hires that fall within that category that will not be covered. Document legitimate business reasons for reclassification. Document policies and procedures supporting the worker classification. So documentation, documentation, documentation. It's a huge thing. It's a difficult effort for sure. It adds an expense to it, but in the long run, it will save you the expense should you go through an audit. Again, the number of clients that I've had over the years, when we have good documentation, the audits tend to be quick, they tend to be certain, and we tend to end up with very favorable results. It's those audits where we don't have good documentation where they tend to linger, they tend to fester, sometimes they go beyond the scope of the original audit, and they tend to, while we still may receive good results, they're not as good as we certainly would have, and sometimes they're bad results. You just can't, do much if you don't have the supporting documentation. So with that, why don't we open it up for a few questions? I know we're short on time.
Hi, Jim. One question that came in is, was asked, by someone, the final rules, just recently came out. Is this a time, a hotel should really be moving forward with everything with healthcare reform, or are there going to be further delays and they should wait to see what happens?
That's a very good question. I think this is the time that you should be moving forward. I think while there will be additional guidance, it's going to be on the edges. It's going to be adding a little more precision to some of the rules that are currently out there. And that is stated in the guidance itself. So, for example, there's some issues that affect higher education that are unique to them. We know that we're going to receive additional guidance on that. I think hotels should be moving forward. I think you should give good, thoughtful consideration. And, the thing is, if there is an additional delay, which I shouldn't say I can't imagine it. I'm in D.C. I can imagine anything at this point. But it doesn't seem like there will be an additional delay. But even if there is, you're still on top of it. I don't see any dramatic changes in the rules absent some dramatic change in the makeup of the government.
Are there any creative ways for hotels to get out from healthcare reform? I know you covered a little bit of this, but can they get creative, with owning different hotels and putting them under different businesses, classifying their employees, and what issues do you really see coming up? Because I know that one thing that we've seen is that there's some bad guidance being given now, meaning that the insurance agent or broker is not advising the HR professional or the hotel on some of these things, such as the measurement period or things like that. Is there any creativity they can do, and then what do they really have to watch out for? And should they be waiting to be told by their carrier or their agent, hey, you're not in compliance?
Yeah, that's a great question. I mean, I think there's a few things. Number one, you have to remember that when you're determining whether you're an applicable large employer, a mid-sized employer, or a small employer, you make that determination on a control group basis. And having analyzed control groups for hotel entities and the way that certain hotels are owned, that is a very intricate and detailed determination. So you don't want to go out there thinking, well, hey, I'm a small employer or I'm a mid-sized employer, when it turns out that you're a member of a control group and you're actually viewed as a large employer. So you have to be careful. And then if you're trying to reconfigure the ownership to avoid that result, again, you're looking at the control group rules, and that's a quite intricate thing that I don't think most brokers are really equipped to handle. You're also going to want to look at your employment, your workers, and there are ways to modify the workforce that are legally compliant, but again, you have to watch the issues that we touched on today. I think the wrong approach would be to sit back and wait for your broker or any entity, really any of your trusted advisors to come to you and say now's the time, because the IRS may actually knock on your door or the Department of Labor prior to your counsel, whether they're a broker, a consultant, or otherwise. So you have to really take ownership on this issue. I would suggest get legal counsel involved so you have the attorney-client privilege, work through the issues, put your game plan together, and then begin implementation. That is going to be the best result, give you the best result in the long run, in the short run and the long run, really.
Great answer, Jim. So I know we're going to wrap it up in just a minute because we're kind of running out of a little time. But I'm going to turn it over to Brock in just a moment. Before I do that, for any of you that really want to get some more training or education in healthcare reform, we do have our Certified Healthcare Reform Specialist program that the Healthcare Reform Center and Policy Institute offers. We have the top national instructors in the country, including Jim, who just did that great presentation. We have the only program in the country with the Department of Labor, the IRS, and the HHS that participate in and really educate everyone on what's really happening with healthcare reform. It's constantly updated. We have a resource center that's available where you can get any answers or questions and watch future updates in healthcare reform. Clearly, I think just spending this last hour with Jim, I think it's obvious this law is very complex. You're talking about the rules and regs being over 20,000 pages, the law itself being almost 400,000 pages, 400,000 words, but the rules and regs being almost 12 million words. And it keeps getting bigger and bigger as more rules and regulations or court rulings are issued. It's very difficult to stay on top of. And I think you definitely need an expert and someone that you really want to work with. I highly recommend that you guys are engaging your attorneys, or if you're working with an insurance agent, broker, or consultant, that they're certified, they're trained, there's something there that tells you that they're really on top of the law, because there's a lot of things you have to navigate with the healthcare reform law. Jim covered 1 hour of what could be, we could have a 20-hour webcast really educating you on all the different things you need to do to become educated in healthcare reform. For those of you that would want to become certified, there's a special code for ILHA 15, where you can get certified at healthcarereformcertification.com and save 15% off if you're an ILHA member. If anyone has any questions, they can email Jim directly. They can email us, and as I said, the webcast will be available later. And with that, I'd like to turn it back over to Brock, the president of ILHA, to close out our webcast.
Thank you, Jonathan and Jim. It's really, really just very insightful, and to everybody who's participated and attended this webinar today. So thank you again to our special guests. And I'd like to remind everybody that next week, Tuesday the 11th at 2 p.m., we'll be having another free webcast. This one is on wellness and medical travel, and it's understanding the marketing opportunity. It's a very, very exciting new, one of the fastest growing parts of the hospitality market, and so you definitely want to attend that one. You can go to the luxuryhotelassociation.org, and there's a link there to sign up for free and attend. So thanks again to everybody, and we'll see you at our next webcast.